My name is Walter Ellis, and I've been in the trucking business for in excess of 40 years, fighting discrimination and unfair labor practices with the large trucking companies. In the process, I've joined up with Mr. Pittman, and we are filing complaints against two large trucking companies, one being Schneider National Carriers Incorporated, for their labor code violations with the Labor and Workforce Development Agency. This agency is one that take complaints against with the individuals acting improper, where they can bring in other complainants as similar to a class action.
Pursuant to the rules set forth in the Labor Code Section 2698, complainants Randall Pittman and Walter L. Ellis, hereinafter complainants hereby file this complaint against Schneider National Carriers, Christopher Lofgren, and Does 1 through 100, hereinafter collectively referred to as respondents. Complainants bring this complaint on behalf of themselves, current and former employees of Schneider, the LWDA, and the general public. Complainants allege that respondents and each of them continue to willfully violate the following Labor Code sections.
Such as subsections K, sections 96, section 98.6, etc., all the way through section 6399.7.
Complainants believe and thereupon allege that Schneider is a Wisconsin company which is authorized and does not conduct business in the state of California.
And does
conduct business in the state of California. Schneider is a module transport company registered with the Federal Motor Carrier Safety Administration, also known as DOT. Complainant Ellis is an aggrieved employee as defined by Labor Code Section 2699.3 because he is a former employee of Schneider and a person against whom one or more of the alleged violations were committed. Ellis is an African American worker who is qualified to work for any employer who operates a business in the state of California. Complainants believe and thereupon allege that thousands of Schneider employees throughout the state of California are aggrieved employees because they have been affected by respondents' unfair labor practices. Pittman, Ellis, and Schneider's current and former employees will hereinafter be collectively referred to as aggrieved employees. Ellis was initially hired by Schneider from May of 1998 to October of 1998. He was rehired to work for it as a commercial truck driver. During Ellis's employment with Schneider, he made numerous complaints to Schneider in regards to safety issues, labor code violations, and discrimination against African Americans. Ellis filed a workers' compensation claim against Schneider for the injuries that he suffered. Schneider has conspired with Ellis's former employer, Central Refrigerated Service, Inc., to blacklist him in the trucking industry. Ellis has suffered financial, physical, and mental damages as a result of respondents' unlawful actions. Schneider continues to use the court system to further intimidate, and harass Ellis in violation of state and federal laws. Schneider has made false statements in court and has attempted to get Ellis thrown in jail in reprisal for him complaining about Schneider's unfair labor practices. Schneider has conspired with CRS in an attempt to financially ruin Ellis because he exposed Schneider and CRS unfair business practices on his website, www.truckscomplaint.com. Complainants allege that within the applicable statutory period for filing this complaint, respondents have continued to willfully violate the aforementioned Labor Code sections as follows. 1. Respondents continue to secretly pay blacks and women less than Labor Code Section 1102.5 states. An employer may not make, adopt, or enforce any rule, regulation, or policy preventing an employee from disclosing information to a government or law enforcement agency where the employee has reasonable cause to believe that the information discloses a violation of state or federal statute or a violation or noncompliance with a state or federal rule or regulation. 2. An employer may not retaliate against an employee for disclosing information to a government or law enforcement agency where the employee has reasonable cause to believe that the information discloses a violation of state or federal statute or a violation or noncompliance with a state or federal rule or regulation. 2. In addition to other penalties, an employer
Go ahead, keep reading.
that in addition to other penalties, an employer that is a corporation or a limited liability company is liable for a civil penalty not exceeding $10,000 for each violation of this section. A violation of Labor Code Section 226 imposes a civil penalty of $1,000 per employee per pay period. In addition to other penalties, an employer that is a corporation or limited liability company is liable for a civil penalty not exceeding $10,000 for each violation of this section. In conclusion, complainants allege that respondents continue to willfully violate numerous Labor Code sections. Wherefore, complainants seek civil penalties pursuant to Labor Code Section 2699.3. Complainants request that the LWDA provide complainants and respondents with a notice indicating whether or not it intends to investigate the alleged Labor Code violations within 30 days of the filing of this complaint.